With our second session for this morning. I think I am the one that's standing between you and your lunch. So I'm going to go ahead and move right on through this, okay, so that I won't be holding you up. So thank you all for staying with me through FERPA 101. So now that you know all that you need to know, right, about FERPA, now that you're someone is laughing on this side, so considering yourself experts on FERPA, let's check it out. FERPA isn't the easiest thing to apply to your day-to-day jobs. FERPA was originally written in 1974. It used to be called the Buckley Amendment. It has been reauthorized, I think the most recent time is 2011. But applying FERPA, that was something that was really written in 74, and applying it to how we do business today in school sometimes can be rather a daunting task, can be sometimes confusing, but it's something that must happen. And many of the violations of FERPA stem from basically not understanding or having a partial understanding. We have a joke in the office when people call in to ask us questions. Based on, you give a question, well, there is an answer, but there's so much more that was left out of that question that we have to give the answer, well, it depends. And then once we give that it depends answer, then we start asking them questions to really get to what the heart of the matter is and answer that. So for the next 45 minutes, 50 minutes or so, what we're going to do is we're going to go through scenarios. Okay? And we're going to work through scenarios, understanding FERPA, using FERPA to go through these scenarios. First one, I'm just going to read what the scenario is, and we're going to talk about it. Divorced parents, Jack and Diane, two young people from small town in Iowa, fall in love and get married. After 10 years and 2 kids, they grow apart and get divorced. Jack moves to California, and Diane stays in her small town, gets remarried, and has sole custody of the kids. Concerned about how his children are doing, Jack asks for access to his children's education records. Knowing that he doesn't live with his children, the school automatically denies the request. Did the school do the right thing? No. Here's the answer. Unless a school is provided evidence that there is a court order, state law, or other legally binding document relating to such things as divorce, separation, or custody that specifically provides to the contrary, FERPA gives custodial and non-custodial parents alike the same rights, basically. And now, and I underline something here. Just because there's a divorce decree or a separation document, if it doesn't mention anything about, dad can't have access to education information on the child, something of that nature, the fact that it's a divorce decree doesn't say the other parent can't have access to the child's education record, okay, to inspect and review his child's education records. Another scenario. Monica enrolls in college and begins attending class. She signs a consent form permitting her parents to have access to her education records. Later, her parent reaches out to the registrar's office, now this is at the college, and requests access to her transcripts. The registrar's office successfully authenticates her parent's identity, but still refuses to provide the information to the parents. Is this okay? What does the school have to do? What does it not have to do? Now, this is a scenario of dual enrollment. Students enrolled in high school, students enrolled in college now. So how do we solve this? In the law, when it says may, that's an option. When it says must, has to happen, right? Well, in the law, guess what? Whenever a student, in this scenario, when a student goes to post-secondary, the law says that post-secondary may share information with the parent. Are any of you in here have students in college yet? A couple of hands? Okay, cool. Glad you're in here so that you're aware. I make you aware of this if you don't know it already. So when a student goes to college, even though they're still in high school, they're not even 18, but remember what an eligible student is defined as. An eligible student is a student that is 18 or enters post-secondary at any age. They are considered an eligible student, and that student gets those rights of FERPA. Okay, so in this scenario, the student is still in high school, but now enrolled in post-secondary as well. For the difference between the may and the must, yes, the college did authenticate the fact that Mary's parents were Mary's parents, yes. But because the law says may, the college doesn't necessarily have to share information with the parent. The student can sign a consent form giving full consent to share whatever they want to with the parent. The student is still being filed on the parent's federal income taxes. The school, that college, has all the rights in the world to share information with the parent. But because the law says may, they can choose not to. I just want you to be aware of that. I've been working in this role with U.S. Department of Education since 21. The worst call that I ever got was from a mama whose daughter was at a private institution. I say that, take that back. That sounds like not a school. A private college, and was footing the bill check. And she said she had just wrote a $38,000 check to pay for her daughter's tuition. And she went to the college and asked to inspect and review. She used the right terminology. She wanted to inspect and review her child's education record, and the college said, no, we don't allow that. You'll have to talk to your student about how they're doing. Well, she went on our website, and she pulled down the consent form, and she gave it to her child. Signed this, turned it in. Everything signed, sealed, and delivered. Still no from the college. It's because there's a may there. So there's nothing in the law that compels the college to share information with the parent, even after a consent form has been signed, even after proving that the child is a dependent and they're still filing federal taxes as the dependent for this child. Just be aware, colleges in Nebraska may not do this. And that's an awesome thing if they don't, if they say, okay, fine, you're the parent, you can see, blah, blah. But just be aware, just in case there's a college somewhere that does it. I wanted you to be aware of that, okay? It's not a good feeling. And all colleges don't do this. Some colleges will say, okay, I have a written consent form from your child, so yes, we have what we need on file. We'll talk to you about how he's doing or how she's doing, or share information with you. But then there's others that have the rule, or they actually have policy at their college or university that says they don't share with parents. So just be aware, just in case you run into something like that, okay? All right, so let's move on to a fight in the cafeteria. Jack started a fight with Keith in the cafeteria that was caught on camera. Jack received 3-day suspension. Keith did not get disciplined for the fight, as it was clear that Jack started the fight. However, Keith received a badly bruised eye injury, and his dad wants to see a copy of the video. The school said no because of FERPA. Does FERPA allow the school to share the video with Jack's dad? On that page, that studentprivacy.ed.gov website, when you go there and you put in videos, and you go to that site, go to that website, you'll see that what is considered to be an education record. If a video is shown, has the indicator that someone was hurt or somebody got ill, it is considered an education record, okay? It is considered an education record. Can the school share this video with Jack's dad? Really, they can. The answer is not no. They can really share this video with, is it Jack's dad? Whoever's dad, Keith's dad, whichever one got hurt. And you will see on our webpage, did someone get hurt, injured, sick, what have you? Those will all be indicators that this is an education record. So the question comes, this is a conversation we had in our office, because then the question comes, okay, so it's on a video, right? Some of us, and I'm sure there's many of you in the audience, you kind of analyze things in a kind of a different way. So, okay, so it's on a video reel. Does the school have to take that video reel, carve out, save, however you do it, save off that section of the video that shows Jack and Keith fighting? No. As long as that video reel is still in that case, it is on video owned by the school, maintained by the school. So there doesn't have to be anything additional done to save. Now you can if you want to, you know what I'm saying? But as long as it's on school-owned property, it's being maintained by the school, and it shows a student get injured, whether it's on the school bus, on the school ground, in the cafeteria, in the hallway, in the classroom, it is considered an education record. Okay? It would need to be, let me help you there. It would be an education record, but we're not saying how long something needs to be retained. That is not FERPA. So if you leave that video reel in there, okay, and let's say Keith's dad wants to see a copy of it, and I don't know, does the video overwrite in 30 days? I see some heads going this way. So, okay, so let's say it overwrites in 30 days. Keith's dad comes in the day after the fight. Well, the next day, that video is fixing to be overridden. Well, as long as there's an outstanding request to see it from the parent, well, guess what? You can't overwrite that. You can't destroy, I'll put it in the words of the FERPA. You can't destroy a record when there's an outstanding request to inspect and review. Okay? Now, okay, so let's do another scenario. The incident happened yesterday. Keith's dad comes in today. Well, you just started overwriting today. Well, you don't have it anyway. Did that make sense? But if you have the video, and it hasn't started overwriting yet, and Keith's dad comes in to view, request to see it, you can't tell him you don't have it, and you can't destroy it, okay, until he has had an opportunity. Good question. All right. School employee. Mary is a database administrator for the school district, and as such, she has a full administrative access to the SIS. Her sister Beth's children all go to the school district. Recently, her nephew gets into a fight and winds up getting suspended. Her nephew refuses to talk about the incident and won't tell his parents who he got in the fight with. Frustrated, Beth calls Mary. Hey, I got a sister that's a DBA at that school. I'll call her. And ask her to look up in the system to see if she can find out who the fight was with. Mary goes into the SIS and finds the discipline incident report for the fight and lets Beth know the name of the child her nephew had fought with. Beth then calls that child's parents up to discuss the incident. Is what Mary did okay? Don't do it. Just because you have access, just don't do it. Don't be tempted. If your family calls you because they know what you do at that, you know how they say it, at that school, you have access to that data for a legitimate educational reason. Remember what was put in that annual notification of FERPA rights? School officials, including teachers and registrars and blah, 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 have access to the education data for a legitimate educational reason. That was not a legitimate educational reason, okay? No, that is not the way to handle it. Don't do it. Just don't do it. All right, another scenario. This is a dual enrollment scenario. Janet is a 17-year-old high school student at your school and is enrolled in the Career Technical Education Culinary Arts Program of Study. The Culinary Arts Program has an articulation agreement with local community college. As such, Janet also is dually enrolled at the community college where she is taking the Artisans Breads and Pastries class. Janet's parents have requested access to and a copy of Janet's education records maintained at both your school, the high school, and the community college. So let's see how we work this out when we've got a dual enrollment situation happening. Now remember, let's see, did I get her age on that one? Yes. Now, first thing, Janet is 17 years old, all right? But she's in a post-secondary. So remember, as an eligible student, you become an eligible student when you turn 18 or attend post-secondary at any age. So in this scenario, the fun and easy way to work through the problem is this. Keep in mind what records are kept at which school. Determine who has rights to access each of the school's information. At the high school, Janet is 17 and a 12th grader. Parents still have those rights there. Nothing changed about the parents' rights, access rights at the high school. However, because Janet is at the post-secondary, now at the post-secondary, Janet is an eligible student. You got me? So she's not eligible student at the high school. She's 17. She's still, the parent still has rights at the high school. At the post-secondary, because she's post-secondary, regardless of her age, she is now an eligible student over here. Parents still have the rights to request to inspect and review their child's education record at the high school. At the college, Janet has to give the school consent, written consent to share with mom and dad, or to prove, parents have to prove Janet is a dependent on their taxes. Was that clear? Does anybody have, did everybody get that?
But even if that's the case, the post-secondary school may.
That's right.
So they can still turn that.
Yes, that's good. Exactly right. So, and that was my next little part there. You just stole my thunder, but that's okay. I'm allow you to do that this time. I'm allow you to do that. That's okay. That's right. Parents may have access to education records kept at the college if Janet signs a consent form and Janet is claimed as a dependent. Parents have the right, they still have the right to access those records at the high school because the parents still have those rights. Okay? Now, are they sharing records? Will the post-secondary institution send information back to the high school? Sometimes they do. And when they do that, those records, when they come back to the high school, even though they're post-secondary records, they take on the protection of the high school. Okay, so at the high school, parents have the right to inspect and review. All right? So even though the college may not share with the parent, if they send that information back to the high school, parents can inspect and review. All right? Cool. Another scenario. The local newspaper is conducting research for a feature article on the increase in student suicides in the local community. The reporter approaches you with a list of student suicides over the past 5 years and requests academic records of the student. Now, can you share that information? May you disclose that information? Would you need to obtain a consent from somebody? How would you work through this? Let's see, the students are deceased. What happens? Well, there is a process. Let's say the student passed under the age of 18. Let's say he was a middle schooler, okay? Well, during that time, parents still have the rights under FERPA, right, to give consent of disclosure of information from their child's education record. So if the child, died under the age of 18, then you would have to reach out to the parents to get access, consent to share that information with whomever, this reporter or whomever. Let's say the child passed at 18 or 19. Well, at that point in time, whenever he passed, remember when a child turns 18, all the FERPA rights go to the child. So if he passed at 18 or 19 or any time after the age of 18, those rights passed along with him. Okay? But and someone asked me a good question in another class I was doing, and they said, okay, so let's say the child passed under the age of 18 and parents had the rights. What if the parents are no longer alive? Now what? Well, if the parents are no longer alive, those rights have passed for that student. Okay? That's how age would matter. The third question there, would the age of the student matter? Really, you got to start working on this answer based on the age of the child when he passed. Okay? And that will determine if you need to obtain consent from the parents or to disclose the information. All right, cyber school. Your district provides parents the option of enrolling their child in an online cyber public charter school. The district uses a third party to run the online school. In order for a parent to enroll their child in the cyber school, the parent must agree to the third party's terms of service, which permits the third party to use, reproduce, or distribute for any purpose the information it maintains on its students. Can the district require a parent to agree to the terms of service of the cyber school in order to enroll that child in the school? Can the district require a parent to sign off and agree to the terms of service? And I'll go back to the terms of service. Terms of service permits the third party to use, reproduce, or distribute for any purpose the information it maintains on its students. Can a district require parents to do that? Answer there is no. You cannot require a parent to sign away their rights under FERPA. You cannot require a parent to say, no, this is the vendor that this district has chosen. It's been blessed by the board, so you need to sign if you're going to go here. Well, whenever you can't, this is federal. You cannot require a parent to sign away their federal rights under FERPA. And signing something that says permitting a third party to use, produce, reproduce, or distribute for any purpose information it maintains on its students, that's like saying you're signing away your rights under FERPA. Okay? Another question. Does the fact that the cyber school is an option for parents and their children make a difference in whether they must agree to the terms of service before enrolling? No. Option or not, you can't require a parent to sign away their rights under FERPA. Are cyber schools subject to FERPA? If they receive a dime of federal funds, they must comply with FERPA. Okay, community-based organization. A community-based organization that has programs for children with special needs approaches you regarding their programs and asks for the name, address, and telephone number of parents with students in your school who have a disability in order to contact parents regarding their programs. You like the programs offered by the organization and believe the programs may be of benefit to the students with disabilities in your school and their parents. Can the names and contact information for these students be disclosed to the organization? I see some no's, and that's exactly right. Because why? You can't release what with what? You can't release directory information with non-directory information. This is like the scenario I mentioned earlier. Does it matter that name, address, and telephone number is a part of our data elements on your directory information list? If you release the names of these students, you have just also released the fact that they are students with disabilities, which is protected, as all information is, okay? So never release directory with non-directory. And it's kind of like saying, well, Lavette, I just gave them the names. I didn't tell them what disability they were. You didn't have to, but you said little Tyler had a disability of sorts. just by releasing this name. There are other ways to do this. If they were to come in and request this, there's another way that you could tell them, no, how about you give us the information and we'll share it with our parents and they will reach out to you if they're interested. That way, you've kept the data safe. You don't have to worry about it. And if a parent is really interested, they can reach out to that vendor, okay, or organization. Parent volunteer. Mr. Spencer is a parent volunteer in your resource classroom for students with learning disabilities. He also has a child with a disability enrolled in the school, but not in your class. Mr. Spencer's assignment is to work with a small group of students on math skills. You provide him with the math achievement scores, classroom test reports, and other math-related information from the special ed records of each student, individual student he is assisting. Here's your question. Is it permissible for you to share the information, share the individual math test scores and other related information with Mr. Spencer without the consent or knowledge of the parents of the student? Can you do it? What would Mr. Spencer have to be considered for you to do this legitimately? Y'all are good. School official. And as a school official, they can be a contractor, they can be a vendor, they can be a consultant, they can be a volunteer. Your volunteers that help you in the office, that may be there to answer phones or whatever they do, or file papers or whatever your volunteers. That's why I was sharing with you earlier in the other session, is to make sure your volunteers are aware of what, the importance of protecting those education records. Because if they have access to education records and they're doing something with them, I don't care if it's nothing but filing them, you are using them as school officials. Okay? And in this scenario, this parent volunteer is actually being treated as a school official. That's why in that annual notification of FERPA rights, you need to have at least 2 sentences in there. One is to indicate what constitutes a school official and what constitutes a legitimate educational reason. Okay? So in this scenario, yes, as long as they're treating this person like a school official, as a school official, it would be okay for him to have access to this information. All right? And they wouldn't have to get consent of parents. Sam is a recent graduate of your high school. After his graduation, he comes to the main office and requests a copy of his official transcript. You notice that he owes several $100s in unpaid fees and reviews him access. He states that refusal to honor his request is a FERPA violation. What do you do? There's one word in this scenario that answers the whole scenario. What's that one word? Thank you. Copy, that's right. FERPA, they are not violating your rights. I mean, FERPA doesn't say give a copy. FERPA says allow them to inspect and review. You can call them in and say, here, sit down. I'm going to pull up your file. You can look at your transcript, whatever you want to do. You can look at it all you want. FERPA doesn't say I have to make you a copy. Okay? And we get this question a lot more in the post-secondary than we do in the K-12 arena. Students have graduated, but they won't give them their diploma or their whatever until they pay the fines, and they throw us out there. No, you're violating my FERPA rights. I'm going, no, we're not. No, they're not. Okay, John is a teaching assistant for Dr. Harsh's History 410 class. After midterms, Dr. Harsh is called away to deal with a family emergency. The midterms are already graded but have yet to be entered into the student information system. Eager to get this off his plate, Dr. Harsh gives John his username and password for the SIS. Over the weekend, John logs into the SIS and enters in the grades from the class midterms. Is this acceptable? Okay, everybody knows this answer. Everybody knows this answer. Is it acceptable, number one, to give somebody your login and password? No, that's not acceptable. Okay, so we've got, it's not acceptable to give somebody your password and login credentials. But let's say John has his own login credentials. Is it acceptable for the teacher, Dr. Harsh, to give John, who is his teaching assistant, the grades to post? I heard yes. I heard something else. Yeah, something that shows he's being considered as school official. Yeah, you're both right. Yeah, exactly right. Now, we are not giving somebody your login. That's a whole nother class. That's called data security. I'm not teaching it this week, so, but yeah, don't do that. A police officer enters the main office, and we went through this in the last session. I really could go through this one, and ask if a specific student is at school today. The police officer wants to speak to the student regarding gang violence that occurred 3 weeks ago and does not have a court order. Can you give him that information? I asked you 2 questions. Can you give him that information out of the education record? No. If the student if you passed him in the parking lot when you were parking your car and you saw him, can you tell him that? Yes, exactly right.
Can you stop him from speaking with the student?
That's outside of FERPA. I can't say. After school program. You mean like just walking up on campus and talking to a student?
Well, if he asks to speak with the student, are you required to bring the student down?
Oh, that's outside of education records. That's outside of FERPA. Wish I could answer that for you. I don't know. By the way, I'm not an attorney. I'm just Lavette. Okay. After school program. Several of your students belong to the local Boys and Girls Club operated out of a local rec center. After school, the students take a private bus there where they play games and get tutoring and homework help until their parents get off work. The Boys and Girl Club come to you and ask for student achievement data on the students that are in their program. They say this data is needed to help them judge whether this tutoring is making a difference. Can you share the data with them? What do you think? Can you share? I'll ask this question in 2 parts. Can you share individual student data with them? Can you share the data in aggregate with them? Okay, thank you. You have a cell size minimum. Excellent. So she said yes if it's over 10 students. And another thing is in that scenario that we mentioned, we did work through earlier, if you're going to share in an aggregate manner, make sure the students aren't identifiable. 10, that's good. Hopefully everybody has a minimum cell size that you use. If you're not, you need to look at those cells and make sure they're not identifiable, okay? That nothing in that spreadsheet that you share with them can identify a student. Now, there are other ways to get around this. At the beginning of the process of the Boys and Girls Club, I think many times they have parents sign something, more than likely. You can actually, wherever that is coming from for the parent to sign, there can be something written on that as well that they are signing that they are okay for schools to release specific information about their child. It can't be, like I said in the last class, the consent forms should not be general. It should be very specific if you want to do it that way. But great answer, good answers. Brian was pushed while riding the bus by another student. When he got home, his arm had a nasty bruise. Mom wants to see the bus video of the incident, but the school said no because of FERPA. The bus driver didn't think much of the incident since, boys will be boys, and neither student was disciplined. Is that okay for the school to share that video? Students weren't disciplined. Does it matter? Because there was an injury. I'm sorry, say that again? Yeah, right, exactly. So both of you were right. Yeah, if it's showing an injury, it's on a video. That video is still in that box, owned by that recorder, owned by the school. School does not have to do anything special to that video to kind of like carve it out or push it. No, if it's on something maintained and it shows a kid being injured, It's an education record for as long as the school maintains it. Parent access. Darren is a senior at your high school. His parents have been involved in a very messy divorce. And Darren has spent the last several years living half the time at each of his parents' house. During this time, his relationship with his mother has soured. The day after his 18th birthday, he decides to live with his father full-time as he finishes his senior year. Sam reaches out to you and asks for you to remove his mother's access to the parent portal, which you oblige. 2 weeks later, you get an angry call from Darren's mother about no longer having access to her son's education records. She insists that this is a FERPA violation and demands that you reinstate her access. What do you have to do? Are you going to reinstate her access? I hear, did she claim him on them taxes? And then I hear, what now? Okay, I heard he's still in high school even though he's 18. And what else do I hear? Darren, I'm sorry. I used Sam in the other. Thank you. Who is Sam? Who is Sam? That's the best question ever. Who is Sam? Why does he care? Anyway, okay. Any other thoughts on this? Any other thoughts? Okay. So first off, how old is Darren? He's 18, and he asked for that access to be removed from for his mom to the parent portal the day after. Well, it doesn't matter. Sam reaches out to you and asks for you to, that's why you asked about Sam. Thank you. Took me a minute. That should be Darren. I'm going to correct my slide. Thank you. That's so good. Oh, that was a good one. Okay, so Darren reaches out to you and asks for you to remove his mother's access to the parent portal, which you oblige. 2 weeks later, you get an angry call from Darren's mother. Well, now, here's the thing. I would suggest you put it in writing, but he can ask, but I would suggest he put it in writing. But the mere fact that he's 18, all the rights belong to him. The day he turned 18, his mom lost those rights. Those rights go to Darren, not Sam. Goes to Darren. She's still claiming him. And if the school desires to share information with him, they may. They don't have to. They are allowed to. But Darren is the one that's 18 and has the FERPA rights. And Darren is saying, please remove that parent portal access. Yes. That is a very good question. I've never been asked that before. We have always stuck with 18 because that's federal law. At the age of 18, that's where these rights move over. So, but that is a good question, and I'm gonna send myself a message, okay? So I'm not being rude and texting anybody. I'm actually sending myself a message to look at that. Even if your state law says 19 as far as that goes. For a legal adult. And I heard another question. Federal law does trump state law in many instances. In some cases, state law can be on top of FERPA, but it can't negate FERPA. Okay? I have never had that question asked, and we have always, everything in federal law says 18. So I'm going to say the answer is still 18. If I find out different, what I will do is I'll email Brian and Jill, and maybe they can communicate that out to everybody, send a blast out. But standing before you, I'm going to say it's still 18, regardless of what Nebraska says as far as when somebody becomes an adult. Okay, thank you. Sure.
So even though he is 18 and what if the mom is still claiming on her taxes, she still doesn't have a right if he says no?
Schools are permitted to share information with a parent. They are not compelled. Because the student is 18, they have the right.
The student can decide even if mom has him on the tax.
Yes. And yes.
What if there was no divorce? Everybody's kosher in that family. If the student is 18 and decides he doesn't want his parents to access his records, he can still do that.
Yes. Because at 18, all the rights go to the student. And I wanted to, I definitely wanted to talk. I'm glad you all are asking questions about this because it really does kind of, you have some 18s in high school, but you more so have them in college. Is that a true statement? You do have some 18s in high school, but you have more so in college. And then you have students in college, 18, 19, 20, and maybe even 21. Parents are still claiming them, right? They're footing the bill. They're still claiming them. I wanted to have this. I'm glad you all asked these questions because that's when it becomes a rude awakening, when you have, gone out, did all this shopping, did everything you know to do, been saving for years, put your kids in college, and now you want to know how the kid's doing. College just says, ask him. Yeah, right. Can I just repeat what you just said? But anyway, so are we, when they turn 18, yes. And you're not going to tell her. Let's put it this way. I won't say absolute no because it depends on the college. You can do a consent form. Your daughter can do a consent form signing said, Mom has the right to inspect and review my education record. You can discuss education information with my mom and turn it in, and that's all that's needed. And they talk to you just like they talk to you as a parent as a high school student. No issues, no whatever. And of course, you're still claiming her as a dependent. So you have you have the consent form, you have the dependent status, you can prove it, on, and turn that into the college. And some colleges will say, okay, here's what you want. But there are those colleges out there that will say, thank you for there was actually a college that had the consent form on their website. Eligible student downloaded the form, signed it, put the names of who he was okay with getting his information, turned it into the college. The college says, thank you, but they'll have to talk to you. We're not going to share anything with them. It is a college by college thing. So I'm just prayerful that all of you send your kids to colleges that go like, okay, here you go, Mom, here you go, Dad. But be aware there are some colleges out there that will go like, I'm sorry, we don't release any information. I've had the calls of, what if I call and can I have my mom listening in? Well, hey, that's what you do on your phone. I can't tell you what you can do on your phone, So there's all kinds of ways. If they're operating in the role as parent at that time, they are considered parent. So say that again.
Can the parents also have that right, even though the child's with other people?
FERPA is not taking away the rights of the natural parent, even though they're not there. But in this scenario, the parent is the person that's taking care of them. I don't want to say FERPA takes away that right, because there's nothing in FERPA that says you can't have access. So that would not be a FERPA. I can answer that under FERPA. But if you were to ask me the question, can the aunt who they've been spending the last 2 months with have access and come and see and blah, blah, blah? Yes, she can, because she's acting in the role of parent.
And it doesn't matter if it's blood relative or whomever, it's whomever's raising.
Right. Mm-hmm. There's a scenario where the kids may, there's a divorce or separation, whatever, and there's a mom and dad over here, and that's his dad, and there's a mom and dad over here, and that's his mom, and he lives over here for a month and over here for a month. Both can have access, because, it's just a part of how they're breaking up that child's time with each one. If the friend is operating as a parent and taking care of that, taking care of that child and so on and forth. I'm sorry, I didn't get your question.
You don't have to have a legal document.
Not by FERPA. Who is fitting that role as parent today? Because in the situation where grandparents are taking, and this happens a lot, kids may be raised by grandparents. You have that happening here. Kids raised by grandparents, and, the mom is in and out. Dad's nowhere around. When the mom's there, mom's taking care of the child. When the mom's not, it's all grandma. Now, there can be legal documents of this, There can be legal documents. In some cases, there will be. In the situation where, they're all living with grandma anyway, and mom is there, and sometimes mom is not. Now, they can sign something, and you can ask them to sign something. FERPA is the baseline. FERPA is the baseline. You all can build policies and things on top of that. You can request certain things. Okay? Good conversation. Any more questions? Because that was my last scenario.
The may versus the must. So what's the point then? If they're dependent and you can go in and say, hey, I can prove they're dependent, I would like access, and they say no. So then I guess my question is why is that legal in there if it's not going to,
I got you. I understand your question. You said, why put it in there if we're not going to compel them to do it, right? You have to talk to a lawmaker about that. Because they use that word may, and they trip you up. And a lot of laws, they trip you up with that may and must. And here it's may. Now, if and when and if FERPA is ever rewritten, these kinds of things hopefully will be looked at. But that's as it stands today.
have there been any big cases that have come up this is just curiosity.
Sure.
In the Supreme Court or things like that regarding the access of student records under FERPA?
Not that I'm aware of. But as I said earlier, if you go out to that website that I gave you earlier and put in letters in the search bar, you will get letters written to schools and colleges and universities all the way back to 2012. And there may be something out there already about it. I'm not aware of it. Good question, yes.
What is the student on IEP and IEP sped records
FERPA still applies to the SPED records, and you may need to check IDEA. They may have additional protections. I'm not an expert on the IDEA side of things, but I do know that they do, FERPA does cover those SPED records as well. Any more questions? This is good. Well, what I will say, I know I had until 11:30, it's right at 11:20. I will say that tomorrow at the office hour session, that is, starts at 1:45 tomorrow afternoon, goes to 2:45, or however long you all want to ask me questions. Please come, and we're just going to be, I don't know what size room it is, but just come, and when I've done this before, and as far as office hours, it's not like one come and wait for that one to be finished and then another one come in. No, it's a room where you come and you sit and y'all just pepper me with questions, get some thoughts, get your thoughts or whatever, if you think of something tonight or this afternoon. And if it's something that I don't know, I'm not going to stand before you and tell you something that I don't know to be true. I will do like I just did and send myself a text and make myself a note and get you the answer. Okay? But please, the information on the screen here, studentprivacy.ed.gov, has a ton of information for you. A lot of documents, a lot of guidance already put out there for you. If you want to call in, you can use either of those numbers, or you can pick up a card off the table as well. And my email address and stuff is on that card. You can reach out to me, and I will follow up with you. I did hear someone wanted to know about the presentation. What I will be doing is I will clean it up, PDF it. I will change Sam to Darren. And I will get it PDF for you, and I'll get it to Brian and Jill. So wherever they post up presentations or whatever like that, if you want to use it, you can. Now, if you're not familiar with our site, I just want to share something with you. This is our site. We have several resources. Here we have a lot of guidance, documents you can come and see. And when you get to guidance, scroll down. There's tons of documents, and it kind of tells you what it's all about over to the site there. So avail yourself to this information. And just anything for SROs, you can just type in SRO here and do the search, and you've got stuff you can read on SROs. This one right here is the 37 questions and answers. It'll come in as a downloadable document, download it, and you'll have questions and answers for all your SRO questions, okay? Hopefully this has been beneficial. You all have been a great audience. Thank you all so much.